Now, the person you ID'd is named Hollis Early. He's a bartender down in Berlin. He has a very good alibi for the night in question.
Your Honor, objection.
Oh, Mr. Goodman, really?
You didn't recognize him either, Your Honor.
Not a way to win friends and influence people. The judge has the power.
$7 million.
Yes, and I am so sorry.
I can do that.
I feel like that $7 million that he would probably pay with would definitely be dirty money.
Whoa, whoa, whoa. Look at you just judging this man.
Allegedly dirty money.
Man. Hey everybody, it's Mark Breyer, a real trial lawyer. Not one of the people on the internet who went to law school and has never actually tried a case, real trial lawyer, talking about some videos. Now today, it's particularly interesting for me because I'm talking about Better Call Saul. And my comments are filled with thousands of people going, hey, it's Better Call Saul. I'm not Better Call Saul. First of all, we'll get into that later. We'll talk about that now. Let's talk about a couple things between you and me. Number one, thank you for watching. I appreciate it. The speed we're going, we're gonna be 100,000 soon. If you're not one of those 100,000, you're gonna feel very bad about yourself. So go ahead and subscribe. Make sure you comment, like everything about the video. All right, listen up, Better Call Saul. This is not me, people.
I want to get down to brass tacks. I want to be very, very specific here. This illness, what does it feel like?
Little interesting thing, in real courtrooms, you see how he's right up on the witness? Most judges will not allow that. In many federal courtrooms, you can't even leave the podium that's a long way from the witness. In state courts, you can only approach the witness usually if you ask to approach and you're giving the witness something. So standing right up in a witness's grill, generally not allowed.
You mentioned it's painful.
It is. There's a tightness in my chest, difficulty breathing, and pain. Burning pain. The pain spreads everywhere.
So here, we have a direct examination. This is where you ask a question, you want your witness to talk. The truth is, you want your witness to be the focal point of direct examination. So being right up on the witness stand is something you would almost never do anyway. Do you know where I often stand? Way back. Do you know why? So the jury is focused over on the witness, not on me. On cross-examination, it might be about me, but in direct, I want the story to be told.
Sounds horrible.
By the way, right here in this scene, the lawyer goes, boy, sounds horrible. Does it hurt right now? If the other side objected and moved to strike, they would win that. Sounds horrible is a lawyer's comment on their own witness's evidence. You can't comment. You're not there. You're not a juror. You're not a witness. You're just the lawyer. Your job is to generally ask questions. You're allowed some freedom, but sounds horrible and also would often get not a very happy reaction from the other side and from the judge.
Some discomfort, yes. Electricity is everywhere in the modern world. But I very much appreciate the indulgence of the panel for their accommodation here today.
Oh, sorry about the exit signs. I guess they couldn't kill those for you.
Well, they're not drawing much current, and they're far away. The farther away it is, the stronger the sword.
So the reason I'm smiling right now is because I've seen Better Call Saul, and later on we'll talk about Better Call Saul versus Breaking Bad. But let's stick to the scene right now because something big's coming, and I'm sorry for those of you who haven't seen this. You don't know why I'm smiling, but you will.
Got it. So if I had a small battery safe from a watch or something, and I got it close to you, close to your skin, you'd know.
I would feel it, yes.
Can you tell us where the nearest source is right now?
I'm trying to remember because I remember the scene. And now I'm wondering, was this cross-examining his brother? Was it direct exam? Because of what I think is coming, I believe this is cross-examination. So therefore, being the center of attention was still fine. Being right up in the witness's face, still not fine.
Jimmy, do you have something in your pocket?
Yes, I do, as a matter of fact. My cell phone. From this distance, you should feel it, and you don't, do you?
Mr. McGill, you were warned to leave your electronics outside.
It's all right, just as I thought. There's no battery in here. You removed the battery. Don't you know by now this is real? I feel this. It's a physical response to stimuli. It's not a quirk. What do I have to do to prove it to you?
I don't know, Chuck. Could you reach into your breast pocket and tell me what's there? Can you tell the court what that was?
A battery.
Mr. Chairman, please.
You recognize that man in back? His name is Huel Babineau. He's on our witness list. You bumped into him in the stairway. He'll testify he planted this fully charged battery on you over an hour and a half ago.
All right, so in this scene, to prove what just happened, to make it really obvious, the lawyer is testifying to what another witness is gonna say in front of the panel. It does make for better drama and it moves it along. And for those of you who've ever been on a jury and you wonder why things take so long, it's because you can't do that. So what you have to do, unlike in this scene, is you have to actually ask questions like, do you have any idea when that was put on you? Would you agree if it was put on you an hour and a half or longer ago, you should have known it? Do you have any idea if you bumped into that person in the back of the courtroom? You can't say what the person is going to say, but you can ask questions, leaving no doubt what the person is going to say.
If something like this were to happen in real life, even if it proves a very valid point and proves that, like, okay, maybe his medical condition is all just a mental thing, it's not a physical thing. He's not playing by the rules, so it probably would not be admissible in this case, right?
The problem isn't what they've proven. The problem is they violated a court order. This is already into evidence. This would probably be allowed because it was into evidence. The problem is what's going to happen to the lawyer who, in proving their case, and in fact proving that the person accusing them is wrong, they've also violated a court order. And there isn't something in the law that says, although arguably in some cases maybe there should be, if you prove that you've been falsely accused of something or been sued wrongly, that there's a little more latitude. You have put yourself at the mercy of the judge. Why? Because lawyers are officers of the court. They swear to abide by the laws and the rules, and therefore you cannot just ignore what a court has instructed you. However, it probably would not undo the evidence, although with the wrong judge, the judge may say, I am going to strike all that evidence because I told you you couldn't bring it. And then we get really complicated. I know it's a long answer to a simple question.
And you felt nothing.
No, it's a trick. It has
Enough
to.
is enough. I submit that Mr. McGill's mental illness is a non-issue. If he were schizophrenic, it wouldn't take away from the fact that the
I am
defendant...
not crazy!
If you're ever on a witness stand, no matter how bad it gets, do not do what we just saw here. No matter how much you want to lash out, and no matter how natural it is to lash out, don't do it. Trust your lawyer to do the job the lawyer has to do. You have to remain calm as much as you possibly can in almost every instance.
He covered his tracks. He got that idiot at the copy shop to lie for him.
Mr. McGill, please, you don't have to go
You
in.
think this is something? You think this is bad? This chicanery? He's done worse. That's billboard. Are you telling me that a man just happens to fall like that? No, he orchestrated it. Jimmy, he defecated through a sunroof.
Okay, so in this scene, we have a witness going on and on and on with no question even being posed. Why would that not happen in a courtroom? Because whomever did not like what the witness was saying would speak up and ask the court to instruct the witness to just answer the question. So in this case, his brother, Saul, Jimmy, depending on where you are in the show's progress.
Spoilers.
His brother would let him keep going because he loves what he's saying. But his counsel would stand up and say, Your Honor, ask the witness to please be instructed to stop, would do something to interrupt it instead of watching your case go down the drain.
And he gets to be a lawyer? What a sick joke. I should have stopped him when I had the chance. And you have to stop him.
It's a good scene.
So they're brothers in the TV show. Does it affect the case? Like, would that be a conflict of interest? I don't know how.
We
does
have
that
it
change
happen
anything?
all the time in real life. Family testifies against family. It happens in family court literally every single court day of every single year in this country. There are absolutely limits. When my clients have been badly hurt, do I call their family members to testify? Of course. Is there a conflict that prevents them from testifying? No. You're allowed to do it. Now, here's where it gets complicated. Can you cross-examine a family member? There's no rule against it. There are rules that generally say whenever possible, a lawyer should not make him or herself a witness in their case. You could get into potential ethical issues if you have to testify in the same case you're the lawyer. Not necessarily, but there's risk. But if your brother is a witness for or against one side and you're the lawyer, you're allowed to do it. I'm sure it would be brought out in some form or another. Are we gonna go to a Breaking Bad clip?
Nice to meet you.
You're not that lawyer on late night television, are you?
Better call Saul. I get it all the time.
We're here to discuss the sale of the property at 9809 Margot.
I get it. Flat fee clients, am I right? Well, folks, today's your lucky day.
That's so great. So you know what's one of the worst things about lawyers? No one can afford a lawyer. Lawyers can't afford a lawyer because they charge by the hour. Generally, it's like this. It's not just an hour. It's by every 6 minutes is 1/10 of an hour. So if you go 7 minutes into your phone call with your lawyer, you just got charged 2/10 of an hour. 12 minutes of a $400, $600 bill. No one can afford that over time. So some firms, to try to make it more affordable and for competitive reasons, have flat fee clients where they go, here's how much I'll charge no matter how much work it takes. Happens in all kinds of areas. And then there's lawyers like me who only get paid if they win. Contingency fee. So there's all different ways to charge. None of them are great. The system's expensive. There's all sorts of negatives.
I represent a client who shall remain nameless. However, for our purposes, you might just as well visualize a large bag of money. This individual wants to buy your house today for cash. In fact, the money is already burning a hole in my client's account. You could ask Mr. Gardner. I've shown him all the pertinent financials.
It's the only reason we're sitting here.
So in this scene, we have beautiful conference room, lawyer, sharp dressed at the front, clearly condescending towards the TV lawyer. This is the big firm. I went to a good law school, I got good grades, and I'm very bitter that you're sitting here at the table with me, maybe doing better than me type vibe. That's the vibe. It's not a real story, it's just the vibe we're getting.
A few papers signed and notarized, we can take care of this right now. In fact, I could wire you your money this very afternoon. There's just one little hair in the soup, the price. Why don't you wiggle us on down to 400, and you got yourselves a deal.
400,000? What is that, a joke?
No, that's my offer.
Well, this is a waste of time.
How could you possibly imagine that we would entertain this?
Come on, hon.
I don't know. I just thought some allowance was in order once I heard about the meth lab. The one that used to be in the basement. I looked over your signed disclosure statements, and I don't see any mention of a meth lab.
So here's what's going on now. A lawyer saying you committed fraud and you're gonna be in a lot of trouble unless you sign this. That's blackmail.
That's illegal, right?
Right? So what we're actually watching is interesting. He's using the fact that, in this case, I won't ruin it for you, but parents have been somewhat important in Breaking Bad. They did something wrong, this wrong. He's using his information on that to get them to sell something they shouldn't sell at the price they should sell it for. Since I never did criminal law, I'm not sure what crimes being committed here, but this would be unethical behavior at a minimum in the way it's being done. He's basically saying what you're about to see, you're gonna be in big trouble unless you totally sell this for a smoking deal you should never sell it for.
No. Oh, you got your termite inspection. That's good, but no meth lab. Now, some would call that fraud in service of concealing a felony. I myself am more open-minded, but it is tricky. I could file a suit and encumber this property indefinitely, or could start some criminal proceedings.
In this scene, a lawyer trying to use his knowledge of wrongdoing to get smoking unfair deal for his client. In this case, he's going, I could start a criminal proceeding. Could he? No. You know who can start a criminal proceeding? The prosecutors. You know who can investigate to help them start that? The police. You know who can't start it? You, me, Saul. So there's this thing you hear all the time in the movies, TV. Do you want to prosecute? Do you want to prosecute? Even sometimes I've heard in the real world, hey, do you want to prosecute? Here's the thing. We actually don't decide. That's why every time you see a criminal case, it's the state versus or the people versus. It's never Mark Breyer versus John Smith in a criminal case. It's the government against John Smith. So he really couldn't do it. Now he could report it and see what happens, but this would be a civil thing and would not lead in many cases to any criminal charges.
How about it, counselor? Do you concur?
I love Breaking Bad. Better Call Saul, really good also. If you actually like me talking about the stuff, you gotta do me a favor. Like this, comment, let me know. I could do this all day. Let me know if you're enjoying it. I'll give you some more real world trial stuff on this not quite real world trial stuff happening here.
Are you present in the court today?
Yes?
And could you point him out to the court, please?
There.
Let the record show that the witness has identified the defendant, Mr. Saki.
You were working at the Sandia Mart the night of the 30th, is that correct?
Got in at noon, left at midnight.
That's a long day. Good for you. Nothing wrong with a hard day's work. So you say, a man came in and he reached across the counter and he grabbed up the money from my register and run off.
Yeah.
And there was no one else in the store.
Not at that time, no.
And since the camera system wasn't working at the time, you're the only one who saw the perpetrator.
Yeah, I guess so.
In this scene, Saul knows where he's going, right? He could just go right in with his point, but then he misses the opportunity to build up and make his point stronger. So everything he's asking now, the witness thinks he's just going along for easy answer right, but he's actually giving more and more ammo to prove the point that's about to be made.
Sounds like it happened pretty fast, but you say you got a good look at him, correct?
Yes.
You must drink stronger coffee than I do, because after 11 hours on the job, I can barely see straight. And it was dark out.
Well, he's the only guy that came in that night that wasn't made up like a bat or a cat or whatever the hell those guys are. And he was right up in my face.
So what's he doing? It's like, you ever say to someone, they tell you something, you're like, are you sure? What do they say every time? Yes. Just asking them if they're sure makes them more sure. If you know as a lawyer that you got something really good, the equivalent of saying, are you sure, are you sure, are you sure, and getting them more and more certain they're right is great, because you have something that's going to undermine them. So I know we're just watching a movie here, but this is a great example, other than the fact that he's right up in the witness's face, which may make for great camera drama, but would not be appropriate. In fact, if you were this close to the witness and the jury they're all the way back, you'd either have to yell in the witness's face. This is not where you would stand for cross-examination. However, the point being, what's he doing? He's getting the guy to double down, triple down, quadruple down because of what he's about to do. Actually, if I can just say to the writers of the scene, it's a nice little cross-examination we got going.
You're not allowed to go that close up to the person in the witness stand. Are you allowed to get close to the jury at all, or are you supposed to stay in the same spot the whole time?
Depends on the judge. Some judges want you to stay close to the podium. Some judges will let you move. Here's the only thing with getting close to the jury. There's nothing wrong with getting close to the jury. You don't want to get so close that you're now making them feel like you're in their space. They're human too. In many jurisdictions now, they're allowed to take notes. You definitely don't want anyone to think you're trying to take a glimpse of their notes. You can do things to offend, but this is about, to some degree, owning the courtroom, especially on cross-examination, making sure that your questions are being heard, and how you move around that courtroom can be as important as the questions you're asking and how you're asking them. It's a great question, but of course, in Better Call Saul, the camera matters more than the jury.
You feel confident that you can identify this person. That's what you're saying.
I can. Absolutely. It's him.
Are you sure that's the person? There's no doubt in your mind. Take your time.
Saul is cross-examining. He said, are you sure? There's no doubt in your mind. When I was in law school, I took 2 trial classes, 2 trial practice questions. I knew I wanted to be a trial lawyer. One of the professors was a judge, and he would say, are you as sure of that as everything else you've testified here to today? And the reason he liked to ask that question is get them to double down if you think you have the goods on them. Not the exact question that's being asked, but he's asking, are you sure? No one's gonna go, oh, I said it, but no, I'm not sure. Of course they're gonna say it. The further they go into how sure they are, the better the next moment is going to be, right? I do sometimes still, from what I was taught from my professor, I will still sometimes say, are you as sure of that as everything else you have testified to here today? Because later, when you undermine that point, it's like, yo, remember what they were wrong about? They were sure that as everything else they told you. But the other side wants you to believe everything else and discount the thing that they were just as certain of that they got wrong.
Could the opposing counsel object for badgering the witness because he's repeating the same line of questioning over and over again?
One, yes, opposing counsel could definitely object for badgering because you can always object. The question is, would it be successful? It's a discretion standard. Whatever the judge thinks is badgering. However, a judge should not call this badgering. He hasn't raised his voice. You're allowed the leeway to be repetitive because you can object for badgering, you can object for cumulative, you can object for asked and answered. So there's a number of ways that this could be objectionable. And some judges would find it objectionable. And I think most of the judges who would find this objectionable are the judges who get on the bench without having ever tried many cases or any cases, which is some of the judges, which is fine because a lot of what judges do is not reside over trials. But when you're residing over a trial, I think you're at a somewhat of a disadvantage you have to be aware of if you never actually stood down in that well and did it. This is actually an effective cross-examination because of what's about to happen in this scene. Also unethical. We'll talk about that in a second.
I don't need time, that's him.
Now, would you be surprised to learn, Mr. Harkness, that the person you just pointed to is not the defendant?
What?
And my client is in the back of the courtroom. Mr. Sakey, would you please stand up?
Objection.
Now, the person you ID'd is named Hollis Early. He's a bartender down in Berlin. He has a very good alibi for the night in question.
Your Honor, objection. Oh, Mr. Goodman, really?
You didn't recognize him either, Your Honor.
Not a way to win friends and influence people. The judge has the power. 2, when that happened, I think in Chicago, the lawyer got in deep trouble, even though it helped the client get off, if I remember, when unraveled after that. Now, I would say this, what do we care more about in our system? Shouldn't we care the most about making sure innocent people don't go to prison? Isn't that our #1 goal? We want guilty people to be punished. We want innocent people to not be punished for the crimes of guilty people. Now, if a witness isn't sure that the person sitting there is the same person they saw that night, shouldn't they have to know that there's a chance the person sitting there is not the person that's being accused. Otherwise, we're just setting it up for the jury to go, yep, you identified him. So we're literally stripping the power of an actual eyewitness identification. Because if I know I just got a point there, and that's the person the jury is accusing, wouldn't it be harder if I knew that somewhere in a courtroom of 20 people, now pick the person? It is unethical. A lawyer got in trouble. I am troubled by a lawyer getting in trouble in this situation. But then again, there's TV shows.
Ladies and gentlemen of the jury, we're going to call it a day. I will have very specific instructions for you tomorrow. As always, please refrain from discussing the case until then, and I will see counsel in my chambers now.
Do you have any unique perspective on any of these clips? Because these are all New Mexico court. So you're licensed in New Mexico. Do you have any perspective you can add to that, being as you are licensed there?
Not even a little. Not even a drop. Because this is filmed in a Los Angeles soundstage. And it's all criminal stuff.
You mean to tell me this isn't real?
I know, it's shocking.
You just blew my mind.
Shocking. However, I really did enjoy that cross. That was much better than the cross we watched earlier, which was not really a cross. What he just did, that was good stuff. I liked it.
Play to the judge, okay? But don't play to the judge. Don't overdo it. Try not to be too cool. I mean, look humble. A little bit scared.
No problem.
That is a terrible way to prepare a witness, but the way a lot of lawyers prepare witnesses. They explain to the client things like, don't do this too much, don't do that, but they never actually role play with the client, and they never have the client explain it in their own words. So you're taking someone who's never been to a deposition, never been to a trial, they've never been through this. They've never even seen it in real life. And the lawyer just talks at the client, who's gonna have to testify or do certain things, and they don't even know what you're saying because they've never done it, never seen it done right. They didn't even have to act it out in your office or in their home. And yet you expect people to suddenly magically be good. And then when the client does bad at a deposition, the lawyer goes, terrible witness. Yeah, terrible lawyer too. So you want to help people prepare for something, right? I would not just explain algebra to you. Well, I couldn't explain algebra to you, but let's say I was good at algebra. I would not just explain algebra to you and then give you the test. I would make you do question after question until you actually knew it. The same is true of this. Telling the truth is a requirement, but it's not enough. How you get comfortable telling the truth so you're ready and you're real. And I've heard it. I got nothing to worry about because I just told the truth. That's great. You have to tell the truth. If you don't tell the truth, you should go to jail for perjury. But you have to be prepared for the situation you're in when telling the truth. How many people stand up and give huge speeches and they never practiced them before? Not a lot of people. Yet somehow people show up in court having never been prepared by their lawyer or gone through it, and we just expect them to magically be great. Can we talk about this for a second? This is the sign of the defense lawyer's conscience defending someone who was involved in the killing of someone else. I have never done criminal law. So allow me to quickly say, what do you think about lawyers who defend people who are guilty? Go ahead, comment. I'm gonna give you a second. I'd love to hear your comments. How do you feel about someone who went to law school and makes their money, gets paid to defend people, including people that the lawyer knows are guilty? How do you feel about that? Is that wrong? Are they a bad person? Knowing that there are guilty people that go to trial every day, are these people terrible people? Let me for a moment give you the other side of that. Power corrupts, and we need to live in a safe society. Good police and good prosecutors to do their job. But even good people, if you give them too much power, will make mistakes. The job of this lawyer is not to have the guilty person found innocent, but to force the state to prove the person is guilty. And if they can't prove it beyond a reasonable doubt, they shouldn't have had the person on trial to begin with, because we don't want innocent people going to prison. It doesn't help the family to later find out, if they find out, that the person that went to prison for the harm they caused wasn't even the right person. That's devastating. Read a book called Picking Cotton if you want to see two sides of the same thing. So everyone loves to come crashing down and attacking people who defend the accused, including people who are guilty. We need people who are willing to do that, to make sure that our prosecutors and our police do the job the right way and make sure they don't cut corners so that the right people go away for a long time and not the innocent people that go away for a long time, leaving, by the way, the monster who may have done it out on the street hurting more people because we were in such a rush to just get anyone to prison to say that we did it. Criminal defense lawyers actually keep us safer. They force the police and prosecutors to do a good job. And I am not a criminal defense lawyer, but it is so easy to hate on them because sometimes they are defending the guilty. But by defending the guilty, it forces all of us to live in a society where we're less likely to have innocent people go away, less likely to leave guilty people out on the street because everyone does their job the right way. Let me jump off that soapbox and go back to the scene.
That's right, Your Honor. Witness tampering. I have reason to believe that the prosecution's key witness was coached by a private investigator who was hired to pervert justice.
Does the prosecution have a response?
Furthermore, the claim that Mr. de Guzman has no ties to the community.
This is a great actor. This is an all about business judge, and there are many. There are many who aren't, but this is great.
Just patently false. Mr. de Guzman has deep ties to the city of Albuquerque. I'd like you to meet his family. That's his fiancée and the love of his life, Beth McKinnon, his stepchildren, Christopher and Ella, and sitting with them is Beth's mother, Mary.
By the way, that would be enough for you to lose your license to practice law and enough for you to go to prison if you knowingly arrange a family to sit there, introduce them to the court as the family, and in fact, it was all a lie. You may go to prison with the accused. Remember before when I was like, I think it's good if you can switch out the witness and force the witness on the stand to identify the person they think they saw commit a crime? This is not that. This is a fraud on the court because this man doesn't even know his fiance.
Your Honor, my client is the only father that these kids have ever known. They depend on him. How can you possibly see fit to separate this beautiful family? You've already held him for 3 days. Given the circumstances, Mr. de Guzman should be granted bond.
Your Honor, a sidebar?
So generally you would not need a sidebar. It's very unusual because there's no jury here. So anything you're saying usually, not always, usually doesn't have to be outside of the hearing of the people in the audience, the public, or the parties. The parties have a right to generally know what's going on, and the public has a general right to know what's going on. So I'm not saying never, but this would be an unusual sidebar because it's not in front of a jury. Now, juries are not allowed to hear everything that's going on because of the rules of evidence.
I accept the defense's argument that bond is warranted. But considering the severity of the charges, I will set the amount at $7 million, cash only.
Oh, Your Honor.
All rise.
$7 million.
Yes, and I am so sorry.
I can do that. Thing is, I'm gonna need you to pick it up.
What, me?
I'll call you.
I feel like that $7 million that he would probably pay with would definitely be dirty money.
Whoa, look at you just judging this man.
Allegedly dirty
Come
money.
on, man.
Would the court pick up on that if that was used? Is that something that they look out for?
That's a great question. He set a $7 million bond. The bond would often be set trying to know the financial means of the person involved. But it's a great question as a personal injury lawyer. I would suspect a decent amount of the money used to get bond for people accused of crimes that involve making money, drugs and other things, would be dirty. I don't know how they would avoid it. It's a great question, I just don't know.
As you can see on the comments there, he's a very good active member of the community. I'm not trying to push blame on him. Clearly he volunteers at soup kitchens and he's a very intimate part of the Albuquerque community.
I remember that, good dude.
The final question I have for you, which one is better? Better Call Saul or Breaking Bad?
It's not even close. Let me tell you something. Believe the hype. Breaking Bad is a great show worth watching. Maybe 2, 3, 4 years after that, I was like, I knew about Better Call Saul. I was like, I'm gonna watch it. And it was good, but it's not Breaking Bad. I've met people that said they like Better Call Saul better than Breaking Bad, and I knew these people were idiots. To everyone who's involved in Better Call Saul, you made a heck of a show. Breaking Bad, just a classic. All right, guys, listen, if you wanna hear me talk about more of this, you gotta comment so I know you love it. Now, if you wanna hear me comment on more shows, check this out right here. You see that? That's YouTube saying, I know you liked what you just saw, a trial lawyer talking about some stuff on TV. Click this one, you'll like that even more. Don't forget to subscribe, comment, and we'll see you next time for Mark Breyer at the Husband and Wife Law Team.